Hello, and welcome to another AIA Colorado Virtual Connect. My name is Amanda Christensen. I am the chair of this year's Business of Architecture Knowledge Committee. And today we have a session that features a presentation on safeguarding the job site, public, and your firm. We're going to hear about a case study that demonstrates how improved project management and execution could have prevented disaster. I encourage you to use the chat box to ask questions. With us today is Alfred Zarlingo. If Alfred can address questions during the presentation, he may do that, but I will join about 10 minutes to close to help moderate the discussion after his presentation. In addition, AIA members will earn one AIA CES Health, Safety, and Welfare Learning Unit for participating in today's webinar. If you have not already done so, please download the case study materials and look in the chat for the link or in your reminder email that had been sent this morning. So it is my pleasure to introduce our speaker today. Alfred Zarlingo is Vice President in the Professional Liability Department at USI Insurance Services. Alfred has over 29 years of experience in insurance, specializing in professional liability coverage for design professionals and environmental consultants with key expertise in sales, consulting, and risk management services. He is also an allied member of AIA Colorado. And USI Insurance Services today is a sponsoring partner of the AIA Colorado. In addition to providing quality continuing educational webinars, AIA Colorado partners allow us to offer many of these programs at no additional cost to our members. Alfred, thank you so much for joining us today, and thank you for your support. Please take it away.
All right, thank you, Amanda. And hello, everybody. Good afternoon. Hopefully everybody's doing well on, as we like to say, hump day. It's my pleasure to be with you once again and to present a case study, which is one of our more popular type of risk management deliverables for our clients. So as Amanda indicated, this program, of course, is HSW qualified, which is great. So with that, I'm going to go ahead and share my screen with you so you can see the PowerPoint that I will be using to help facilitate today's program for essentially the next hour, finishing right at 1 o'clock. So really the only material you need to follow along at some point here in about the next 10 to 15 minutes will be the actual case study itself, because we will take time to read the actual case, and then we will come back together and we'll digest that and go through some of the key points and then open it up for some questions and answers. So with that being said, hopefully everybody can again see the program first slide here based on today's program. So let me go ahead and advance.
Alfred, can you please share your screen?
Okay, is it not sharing? All right, hold on. There we go. Okay, let's try that. Bear with me a moment. Let me make sure I'm sharing the right screen here. And let's try this now. Okay, there we go. Okay, so hopefully everybody sees that okay.
Looks good, thank you.
Yep, thank you. Okay, and obviously for the HSW and the continuing education, we have the slide from our friends at AIA Colorado with the material being approved. So we have our disclaimer there with AIA. The next screen is just letting everybody know that the author of today's case study is the insurance carrier AXA XL. They are one of our go-to markets that we use at USI, possibly the firm you're with, or your company is insured by AXA XL and you're a customer of USI. And then the course description, I believe everybody saw this as part of the invitation. So again, just highlighting the case study that we're going to be talking about today, about a historical building and the pitfalls. And like all good programs, and of course, for the sake of getting the 1 hour of HSW, health, safety, welfare, for today's program, of course, we have the approved learning objectives, which are again authored by AXA XL, along with USI, and then approved by AIA coming from the national office. So our objectives are, we're going to talk about some of the poor contracting services that we'll see, talking about scope or lack thereof in this particular case. We'll talk about the importance of CA or observation, CA being contract administration, and then so that's learning objective 2. The third one being talking about the importance of documents or documentation to support your design, if you will, and which is, and of course, as the last handful of words are in the third line of the third objective indicates, is keeping the the public safe, because even though this is not an ethics class, we all are reminded that the importance of ethics, usually the number one rule of being ethical is to hold the public safety, welfare at a very high level. So very important, and we'll talk about that a little bit in today's case. And then the last objective, talking about the lack of roles or the lack of safety. Now, granted, as an architect, of course, you're not responsible to provide job site safety means and methods. That it falls with the general contractor or design build entity. But even so, we still have some concerns around that, given the nature of this case. So those are the 4 objectives we'll be focusing in on. And then of course, our agenda. So I'm going to open up, talk about kind of laying a foundation, if you will, before we start reading the actual case. Talk about what we call risk drivers, which is a foundation of many of the workshops we deliver for our customers, thanks to our partnership with AXA XL. These are the reasons, essentially, why firms are at the table, having to deal with a dispute or an allegation, or maybe even a demand or wrongful act. And we'll talk a little bit about that. Then we'll talk about, again, we'll read the case study itself, take about a 10-minute period of time to do so. And then we'll reconvene and obviously talk about the key points, and then of course get to the end of the story based on what's called the bottom line. Okay, so with that being said, let me just begin by sharing with you, because these are the key points that I want you to be thinking about when you read the case itself, is that knowing that, of course, statistically out there in the industry, whether it's a flagship professional liability carrier like AXA XL, who's writing lots of A&E firms around the country in all 50 states, and they find that in any given 5-year window, they have oftentimes as many as 17 to 19,000 case files open, some of them of which are claims, others are what we call circumstances. And what they've been able to do since about 2001 is they've been able to, as I like to say, dumpster dive into the data and really find out why their clients, why firms like yours are at the table. Why are there issues? Why is the client unhappy? Why do we have possibly a claim? Now, we talk about in the policy that there's a claim is essentially, one getting sued right away, right? You serve papers through an attorney. That by definition is going to be a claim, but a claim can also be a situation where the owner is demanding money from you or requesting you to provide additional services. And they don't have to necessarily hide behind an attorney law firm to do so, but if you get that type of communication, that by definition is going to be a claim, again, a demand for money or services. But the flip side is you can also have a circumstance, which is essentially a situation where change condition, maybe you're looking to terminate your services, you want to leave the job site, or possibly the project's been completed and there is a dispute, but you're not directly involved, but somebody, either the attorney representing the contractor, developer, or the owner is requesting your documents, or they want you to be a part of what's called a deposition. So we can oftentimes turn those loss prevention matters in as a circumstance and seek assistance. So when the carrier like AXA XL is gathering all that data, they've been able to determine up until just a couple of years ago that there's 4 driving non-technical factors, right? So we know that 20 to 30% of the time, the reason why you're at the table is because you've been able to identify the immediate mistake, right? There's an error, act, or omission in your plans, in your design, maybe something you specified material-wise failed, and you've immediately noticed that. And of course, we would say, don't ever fall on the sword in the field and tell your client that you made a mistake, but fall on your sword back in the office when you determine that. So those become very evident, right? 20 to 30% of the time, but yet they don't exacerbate themselves later on the remaining 70, 80% of the time, because the reason why you're at the table is because of one of these 4 items. Either we're talking about a bad contract, a contract that was not negotiated, never executed, scope development is part of that too, because when we see, as you're looking at the PowerPoint slide, the very first bar graph on the left, it's a combination of negotiating the agreement, but also contract management. So developing it, creating the scope, and then managing the contract from the standpoint of conceptual design through CA when you get to substantial completion. And the good news is collectively within the industry in the last probably 12 years, this has improved. It's actually meaning that through organizations like AIA Colorado and others out there within the membership groups for design professionals, we have seen a lot of scope development courses, the importance of sometimes using the attorney, leaning on your broker for what's called an insurability review. Myself personally, I am not an attorney, and nor does my colleague or the office provide legal assistance, but we do have partnerships in the industry to put our clients in front of an attorney who is a specialist with architects and engineers. So all that combined has created a decline. So you're seeing a drop in that non-technical factor. But keep that in mind as we read the case. Moving on to client selection. Client selection is just that. How well do we know the client? It is what I like to say the first step to risk allocation. You have to know the client. Now, sometimes, of course, for many of you, your client is the client. It is the person who owns the project, has the money, pays you, so you can continue to pay your bills and then pass through if you have any sub-consultants. Sometimes it gets a little tricky with the engineers, and I realize I'm not speaking to an engineering group, but for the engineers, they'll oftentimes say, well, my client is the architect. And I said, well, that's great. But at the end of the day, who's the architect contracted with, right? Who are you ultimately working for? And that's really the mindset and the collaboration as a design team to really understand who is the customer. And sometimes what happens is firms will run to a project and they get to find out who the client is when it becomes too late. It's that hindsight's 2020 notion, and that's a bad place to be, to find out that you're ultimately working maybe for a very bad client who's very litigious. So getting to know the client, and so when we work through a workshop called client selection, we put a lot of Q&A out there because it's just that you need to ask a lot of good questions, really understand the clients, get to know the client, get to know their expectations, and why is it they want to do this project, right? There has to be that need, and then again, meet expectations. Thankfully, this particular bar graph, relatively flat. I mean, there is a slight uptick, but it's been, at least since 2009, as you're seeing, as we've seen in some updates, that this particular, it's holding the bar in that low 20s. The next one is project team capabilities. This one's pretty straightforward. It's either you or your firm have the capabilities or you do not in order to take on the project. So we have to keep that one also in the back of our mind, That is, did the design firm involved in this case study have the capabilities to do the work? Sometimes what happens here that creates a lot of play on the analytics is that sometimes the project that comes in through the front door, the firm has the capabilities, but the team that's assigned to the project may not have or has lack of controls or knowledge related to the project. So sometimes the immediate identifier of saying that it's an external project team capability problem. That is, yeah, we're a firm that does residential, and yet why are we doing a church project, for instance, right? And that would be a good question. But if you're a church consultant and you have a church project that comes in, do we have the right project manager and team involved in that project, given going back to the client selection, knowing, again, who the client is and so forth. So we got to get it right, both externally, internally. And then lastly, communication. This is a big one. This one continues to dial north. Communication is the breakdown or lack of communication skills. It could be a combination of failing to listen, it's failing to document, it's failing to communicate properly, keeping it simple, whether it's on the phone, in person, in an email. And we need to make sure that the communication lines are clear. We understand who we're talking to, we understand our client, and we get to know, better yet, what is our client's language and communicate accordingly. But you'd be surprised, even though we deliver a couple different workshops in this space, we have one called Truly Loss Prevention Through Better Communication, and we have a newer one out today called Email, the 7 Deadly Sins. I always tell clients that it's not rocket science. I don't come to the table with those deliverables and bring a secret sauce to say this is the way to do it. It's just common sense and taking the time and slowing down and making sure we're dotting the I's and crossing the T's. But nevertheless, communication does get us into trouble. So with that, I'm going to go ahead and move right along. Now, I believe, Amanda, we're going to keep a chat box open. So if anybody along the way of today's case study at any given time, of course, you can always table your question for the Q&A session. But if you do have an immediate question, the chat box should be open, and I'm happy to take a look at that. And Amanda, if you see something in there, please give a shout out, and happy to answer the question. Okay, so with that being said, let's go ahead and have you take the next 10 minutes and read the material. This is the case study itself. So hopefully everybody has that attachment from the invitation that was given to you by AIA Colorado. And if anybody has any questions, please give a shout out. But in the meantime, I will go ahead and just go ahead and stop my video and let you go ahead and read the case study. And of course, please take notes, because we want to talk about possibly some, I'm not suggesting everything is bad here. There might be some good stuff. So make notes of positive as well as negative items, and we'll, like I said, we'll reconvene in 10 minutes. So right now I've got just a little after 12:15, so we'll come back shortly after 12:25. Thank you. Go ahead and take another 2, maybe 3 minutes most. Again, you're reading primarily the first couple of pages known as the facts of the case, titled Arch Enemies from our friends at AXA XL. Happy to have you take a look at those key points if you like, if you've already digested the material, but no need to jump ahead if you're still making notes, comments to yourself regarding the first 2 pages. Okay, another minute. Okay, so let's go ahead and jump into the case itself here. This is a good time, again, looking at the chat box for those of you participating. Let's look at that very first page, the page on the facts, right? This is where we get the cast of the characters. We read into the heart of the case. And by the way, this is not a made-up case. I want everybody to know that this is a real deal. This took place probably close to about 20 years ago, because I remember when I first started working at USI, formerly Van Gilder Insurance, back in the later part of 2000. I was brought up to speed. This was one of the very first case studies that was brought to my attention in 2001, and it happened right here in our own backyard. So right here in Colorado, obviously for the sake of confidentiality, we being AXA XL, who we are approved brokers to represent, they of course, they authored the material and changed the names of the guilty, if you will. But nevertheless, we did have a couple clients involved in this particular project in a historical building in the mountains, if you will. So can somebody just take, this is a good time to, again, use the chat box, but it'd be nice to hear from you and just let me know what are you seeing that's a concern here within the case study. Anybody want to go ahead and take a shout out in the chat box? And I've got, looks like we have Alyssa, Ashley, Brad, John Paul, Juan, and Zach. So anybody in the group would like to go ahead and share possibly what you're seeing as a concern? And I'm going to bring up the key points here, but otherwise, so thank you, Alyssa. So yeah, so we have, so the young Mr. Winkle, did not visit the site and was not familiar with it, right? So he was the son of the structural engineer, asked to provide additional services back to the architect. Yeah, definitely that was very concerning. Brad, I appreciate your comment. Okay. Yeah, owner, contractor only have the architect and structural engineer to blame, right? So let's talk about that. If you were the architect, is this the type of client you want to be working with? A client who both owns the building but decides to play general contractor at the same time. And my question is, how experienced is this client? Does he have a contractor's license? Is he a, what has he GC'd in the past? And what's his expectations? What's driving him to do what he's doing? Is it a cost saving measure, right? Because what kind of people is he hiring to do the work? Are we talking about just handymen or a man or men versus, again, a sophisticated crew that, of course, and of course, being an insurance broker, the concern is who has insurance on this project, right? Well, we can probably presume that the owner has a policy on the building for building coverage is related to the property and maybe some premise liability. But again, is there a contractor's general liability policy in play? Workers' comp for the employees doing the work? It becomes possibly a recipe for disaster depending on what the answers to the questions are, right? And too often do we see situations where the design professional comes to the table having obviously all the above coverage, right? Because we all know that, it's important to have good insurance. And as an educated design professional holding a license and going through various courses and working with a good broker, much less taking advantage of a lot of good classes through AIA Colorado, you come to understand that, sometimes you can't get on a job site, much less get paid if you don't have the insurance. And then you need to stay compliant with the state if you have employees, and you want to do the right thing. So with that becomes obviously an issue too, because when push comes to shove and we have a problem on the back end, yeah, who's the owner pointing the finger at, and who's going to step up with insurance? And chances are, oftentimes it might be yourself, because you're the design professional involved in the project. And unfortunately, you're guilty by association, and then you got to go through the process of clearing your name and determining that in fact you were not negligent, and you walk away from the table. But unfortunately, you're at the table to begin with, but having good insurance, you'll be defended and all that good stuff. So, but let's talk about one additional item here early in the process as I'm looking at the case. Anybody like this particular soundbite? Even though it was a small design job, just a few drawings really, they simply shook hands and got down to work. Is that an appropriate contract? We call that a verbal agreement, shaking hands. Old school, absolutely not, right? We need to secure a contract. If we remember from the slides, it was one of the non-technical factors that drives claims and issues, is that lack of a contract, non-negotiated agreement, and maybe no scope development, much less managing the contract and keeping the client educated, especially when there's change conditions and maybe additional services being contemplated. So that becomes very critical. So that's the very first, as you're seeing on the screen share, lack of written agreements, right? Key points, right? Would have helped delineate who's responsible for certain scope, right? Managing and allocating the risk. And when we talk about even allocating risk, I don't know if any one of you is familiar, but within AIA contracts, one very good risk allocation tool that's built into many, if not all, AIA agreements, and we're talking about, of course, the most current ones, 2017 and forward, is we're talking about what's called the consequential damages clause, right? It's a mutual waiver that says that neither party will sue the other for any soft costs related consequential damages. So, if we've got a client who says, hey, I got a problem, it's going to cost $50,000 to fix it, but all the while I'm not able to operate my business and I'm losing X amount of dollars per day for 30, 60, 90 days, that's a consequential damage that is covered by your professional liability insurance. But yet, how nice would it be to avoid a $200,000 consequential damage loss with a $50,000 fix and be out the door $250,000, but rather only have to pay $50,000 because you kept the consequential damages clause provision in your contract. So that's a really good perk. Another really good risk allocation clause, again, by having a contract in force, is called limitation of liability, LOL. And that's another good clause to consider. Unfortunately, it is not a clause that by default falls in the contracts with AIA. So you do need to write that in as a miscellaneous provision, but it's limiting your liability to a cap. Whatever that cap is that you agree to with your client based on the fee or X amount of dollars, whichever is greater. Okay. So again, we did not have either of those, right? Because again, no contract means we have nada, we have zilch, zero, and we're at the mercy of trying to determine when there's a dispute who said what and what was agreed upon. And maybe we have some documentation to back that up through emails, maybe some handwritten notes. But again, that's a big hope, if you will. So something to keep in mind. Obviously, the agreed upon dispute resolution, right? Again, another key provision within the contract. That is, okay, we've got a dispute, client's not happy, and yet how are we going about this? Are we going to go we're going to go to court, we're going to go through litigation, or are we going to go through the means of alternative dispute resolution, which could be non-binding mediation? We get in front of a mediator, or which again is non-binding, or are we going to maybe agree to arbitration, which is a binding dispute resolution mechanism? Now, what we tell our clients is non-binding mediation first and foremost, failing that litigation, if you will. So, and the nice thing about non-binding mediation is statistically, it's usually quicker, fairer, not a lot, again, less time, better results as far as payouts. And then on top of it, of course, a firm like the one you work for or the one you own, it would actually, your professional liability policy, if it's a good, robust policy, whether it's AXA XL, could be somebody like Travelers, Berkeley, Navigators, who's becoming Hartford. Those are some of the other key partners we work with. They'll have a mediation credit built in so that oftentimes if you mediate successfully and settle the dispute, you'll actually get half your deductible back within your policy. And so there are some advantages, obviously, of staying within that dispute resolution. So with that, that speaks to that very, again, first non-technical factor. Again, the fact that no contract means we're not really negotiating much. The scope is to be determined. The hope is, again, we're following up an email, maybe identifying what the scope is, what we're doing with the client. But in this case, we definitely get the feel that things were very loose, laid back. Maybe the question that I may pose to the group is, did the architect previously work with this owner? So was there a pre-established relationship? And if so, that may have maybe created the easygoing feeling of, don't worry about it. Let's shake hands and we're good to go. And And that's all fine and dandy until there's a problem. And then, because the question I'll throw out there as well is, when you do have a dispute, you do reach out to your broker and or carrier directly, but usually, at least for us, we like our customers to contact us directly to discuss the issue and report it. But once we get a report and we churn it in and a claim consultant is assigned to your file, what is the very first thing that a claims person with a professional liability carrier is going to ask you for after you churn in the dispute? Okay. Anybody want to take a stab at that in the chat box? What's the item that the claim consultant's looking for from you? Almost the very first document that comes when there's a dispute. Anybody? Yeah, absolutely. Very good, Ashley. The contract. And what's the problem going to be here when Ashley, I'm the claim consultant, I say, send me the contract. You're going to say, I don't have one. And I'm going to say, okay, well, what do you have? And that's when you're going to have to pull it all together from your project file and say, well, I've got some handwritten notes. Maybe I've got a sketch on a napkin. I've got some emails. Send me what you have, because I need to create a puzzle here. But I'm kind of creating a puzzle without actually knowing what the picture is going to look like when we put it together. So very good. So again, very important. Next key talking point, client selection, right? I think I hinted at this one early. Who's the customer? And we've got a client who ultimately is, of course, playing both the owner and playing the general contractor, and who's looking to manage the project. Now, we have very little intel on this particular case, so I obviously some of my talking points, especially now, suggesting that maybe we had a client who really didn't want to spend a whole lot of money, right? Wanted to keep it simple. Obviously didn't pay a lot, because we've got the structural engineer getting paid, I think it was $500 for the initial service. So not a big ask, but nevertheless, keep in mind, we did not have a contract between owner and architect, and nor did we have a contract, or better yet, even just what's called a simple letter of agreement. But we had no written document as far as an agreement goes between the architect and the structural engineer. I think you would all agree there. I don't think I'm missing that point. So we had essentially no sub-agreement, right? Okay, so, but again, the client we talked about, again, very important, because very troubling, obviously. Hindsight's always 20/20 when we look back. And if the gut feeling is telling you something's suspicious, I don't really feel good about this situation, ask more questions and talk to your peers. Go to your inner circle and talk with colleagues and associates, because if you feel like, at the end of the day, it's just not worth it, it's okay to say no. And the good news for most firms today, at least in my experience, is many have a pretty well established pipeline right now. That's some may say it's overwhelming, others saying it's just right. But as long as you got a lot of work going on, it's okay. You don't have to say yes to every opportunity that comes in the door. It's okay to say, again, because at the end of the day, I'll probably say this again later, even a small project fee, small project opportunity can still be a very costly claim when all's said and done. So you got to be very cautious and determine, is it even worth your time? Especially if you're not getting a contract, you have, again, a situation of an owner playing general contractor and so forth. Okay, but I liked, so before I get off this very first page of the case is, I think early on, Alyssa, you indicated, yeah, we had, again, we had no site visit when it came to Mr. Winkle. Now, what other kind of site visits generally do we like? And you're seeing this in the key points again in the screen share. And we're talking about observation of the work in number 4, right? Did anybody see or read anywhere that any design professional, whether architect or structural, actually, maybe outside of an initial site visit up front to meet the client and maybe get a walkthrough possibly of what was needed, maybe that was solely the architect. I don't think the structural engineer, frankly, was even on the site from what I recall. And then on top of it, did anybody even do any kind of observation when it came to, okay, I need to be out there and do general conformance. I'm going to agree to X amount of site visits. That's appropriate given, the standard of care related to the project, the scope, to make sure that, again, it's in general compliance and the contractor, or in this case, the contractor's handy men or people that were hired to do the work are actually doing the work properly. But again, you're not there to provide job site safety, right? But if you see an unsafe condition, is it your responsibility to give a shout out? Absolutely, right? Because even if it's could be the employees of a say a subcontractor, somebody obviously who was hired. Maybe we had an electrician come in, we had a crew doing physical work, but never, we're hoping that, of course, those people have insurance. It's the responsibility mainly, since you're not being hired by the general contractor, at least a true general contractor in the sense of a company with employees and materials and equipment. But here we have basically a paper contractor who's hiring people to do the work. Again, great time early on to say, okay, great. This is what you're going to do. You're going to play GC. What's your experience? Who are you hiring? Are you actually going to bring in an insured party and people that have experience, or are you just hiring people off the street to do the work? Because that's going to be, depending on those answers, that's going to be a concern. But again, observation is going to be important, right? And again, remember, CA is contract administration. Too many times, I know it's for, I think it was precursor to 2007 AIA contracts. So it's the 1997 and older editions. But for a long time in the industry, and I'm not certainly pointing the finger at AIA, but it was everybody collectively, CA was defined as construction administration. And I would beg to say, is anybody really administering the construction at a job site? Because that is not something you want to be signing up for and taking on. So keep in mind that CA is contract administration, or maybe consider construction contract administration, which I think is the terminology we see here in today's case study. But had we had site visits, right, there probably would have been some things would have been picked up that could have been controlled and avoided, obviously, the outcome that we see here, which of course becomes people involved in the, we have a boutique, beauty salon, and we have a restaurant on the main floor of a 2-story historical building. And so we've got debris and materials coming down on the patrons down below, causing some harm. So not only do we have property damage, but we have some bodily injury. And again, it's back to, again, ethics, right? Holding paramount the health, safety, and welfare of the people. And so that, to me, that implies both innocent bystanders, third parties, again, employees of, seeing an unsafe condition. So, when you walk a job site and you see somebody who's not properly harnessed, not wearing safety gear, walking by even, say, a trench where the trench is not shored off, and somebody's in it, what do you do in that circumstance, right? And we call that imminent danger. And so those are the things, you need to be concerned about, because thankfully we didn't have anybody get killed in this particular case, but we did have an injury and, of course, some mental anguish coming from the person who got, I guess, spooked by the moose that was hanging on the wall. So I'm looking at the chat box, but again, if you have any comments, please don't hesitate to throw something out there, but I'll keep moving everything forward for us. Project selection, don't want to skip over that, but number 3, okay, just a comment here. Renovation is often risky due to the lack of record docs and unknown conditions, especially when we're dealing with a historical building, right? Building that's 110 years old, documentations are going to be probably more difficult to come by based on what the conditions are, when the last renovations have been. So there's going to be a lot more due diligence that's probably going to need to be done before just jumping in with both feet. And I think it's fair to say that the architect and the structural engineer had the capabilities to actually do this project. I didn't pick up personally on anything that suggested that it was outside of their expertise. Okay, number 5, incomplete documentation. So we're talking about, complete set of drawings and records. Obviously, the fact that we didn't have a contract doesn't help. But, the documentation collectively, especially on the back end when a dispute arises, was very little, if you will. So it did not help to support the case when it came, obviously, when the matter blew up and the owner GC started pointing fingers at the owner and the structural, if you will. And then the communication piece, right? This is the one I was talking about earlier. This is dealing with the largest non-technical factor. So obviously some good key points here under the communication piece. Okay, the assumption that someone else had performed a critical task. Okay, so we all know what the word assume means. So the fact is that kind of came back to bite the parties involved because of, again, the outcome of what occurred. Okay, right, the owner assumes that the structural engineer did provide that, well, I don't like to use the word inspect, but did a site observation precursor to providing services. And then, of course, the architect, we're told, assume that, again, the structural engineer would have pointed out dangers. And then, of course, the structural engineer is going to turn around and have his say about, again, having the wall compromised based on some lentils to create some doorways on that top floor, right? Because we were told that I think the second floor was unoccupied, so vacant, and so it sounded like it was going to be a build out to create a couple apartments or a couple condo units, depending on if those are going to be for rent or for sale. But we were going to have residential units on that second floor. Okay. All right. All right, so let's go ahead and before we get to the bottom line, take a moment to peruse over the next couple of pages in your case study. Just want to make sure that we're not missing anything in our key points. And then we'll get to the bottom line. We have about 6 minutes left, but based on the lack of the key points, this is, there's some headings here. We talked about the lack of written agreements. Highlights here, right? Importance. No one, again, the fact that we didn't have any type of scope to follow. Okay, we talked about the client selection, project selection, inadequate observation of the work. That's huge, right? And I can definitely tell you that statistically, claims increase 2 to 3 times greater if there's no CA involved in the project. So I know for some firms that's a deal breaker. If they're not providing CA, they're going to walk away from the project. And they're not in the business of just doing a design and putting it out there. Now there is contract language, of course, where you can do, design without CA, and and it's important to make sure you have that additional indemnification clause in your contract. But it's, I've in the 20 plus years I've been around some of your colleagues and fellow AIA member firms, and cut through, the customers we service, they'll talk about the importance of contract administration or observation. And again, it's extremely important because it helps manage risk. And then lastly, incomplete documentation and inadequate communication, right? So all the things that we talked about are rounded out into key points. So go ahead and turn to that last page, or at least the page that indicates bottom line. And go ahead and read that, please. Okay, very interesting, huh? Kind of that would have, should have, could have. But as you can see, and I'm somewhat flabbergasted here, 4 years to actually settle this claim, which seems very simple, but yet it took 4 years. Don't know why it took so long, but I can definitely tell you time is money. And with a $340,000 settlement, of course, this is over 20 years ago. Who's to say that this settlement would not have been well over $500,000 in today's modern times? But keep also in mind, this was split equally between the two parties, the structural and the architect. And of that settlement, it also includes defense costs, right? So we've got the cost of the attorney's involvement from the carrier, the expert witnesses involved, and other resources, including probably in the case of, this went to litigation, so judge and jury. So there could have been obviously some court fees. So to really say what the settlement was without the defense costs is very difficult. But over a course of 4 years, I'm sure during that course of 4 years, there was a lot of dormant time where things just kind of went quiet for a while. And but even so, it may be fair to say of $170,000 per each design professional, maybe $70,000 might have been the cost of the defense and $100,000 settlement. But that's kind of a best guess there. But nevertheless, a lot of money, right? Given that, again, the structural engineer was paid, if I recall, $500. We don't necessarily know what the fee was to the architect, but oftentimes I see in the fees, maybe a structural gets 10% of what the architect gets, maybe 20%. So my guess is the fee to the architect was well below or at $5,000. So to have a $5,000 fee, probably to be at your deductible, which was probably another $5,000, and to have a $170,000 settlement, that's a big pill to swallow. And with that being said, why don't we open it up for some Q&A then, Amanda?
Yeah, we're actually coming up at our 1 o'clock. So if there's any kind of closing remarks, Alfred, that you'd like to kind of make, we've got a minute to do so.
Okay. So yeah, the takeaway obviously is, as I stated before, small problems can be big problems. So so even with the smallest of fees, small small project, you still need to take into consideration the importance, like you would with any larger opportunity, to do your due diligence, get to know the client, get a contract in place, develop scope, get a healthy fee, and negotiate the key critical phases, including CA or observation. And again, it's okay to say no. It's okay to walk away. But if it's a good opportunity, then stay true to the course, because at the end of the day, as I like to say to all my customers, is you do not want to be the next case study, right? You do not want to be involved in a claim, because one last thing I'll mention to everybody here is when you have a claim, is there's a lot of time spent. And statistically, they have told us that on average, it takes 200 hours to take care of a problem. And if you're getting billables of $100 an hour for 200 hours, what's that? $20,000 of lost revenue in the time spent dealing with the problem. And then on top of it, if you have on average a 10% profit margin and you try to recoup that loss, it may well take you a $200,000 fee on the next opportunity to make you whole for the time that you spent chasing a problem to just get you back to even keel. And when you hear that statistically, that's kind of a very large, eye-opening wow, or catch you, if you will. So the reality is, keep doing what you're doing to avoid claims. I know sometimes when we do our very best, issues do arise, but with a good client, good contract, and a good company that's insuring you, you can always find a good outcome at the very end. So lesson learned, stay away from this case study and hopefully learn some of those key points and sharpen the tools in your toolbox and keep doing what you're doing and stay safe. So thank you for the time. That's it for me, Amanda. And
thank you so much, Alfred. And I wanted to also thank USI Insurance Services for providing this webinar today. And thank you to all of our members here today for taking time out of your busy schedules to join our conversation. Please join us next Wednesday for a virtual Connect webinar featuring exclusive advocacy news and insights on key issues impacting architects, projects, and the design and construction industry. So thank you all so much and have a great afternoon.
Thank you. Take care, everybody.